Right now, we're going to talk about brokers, and this is on page 67, Commercial Law for Business Students. A broker is a mercantile agent who, in the ordinary course of his business, is employed to make contact with third party or third parties for the purchase of goods. So his mission is to purchase goods or property, real estate, or for the sale of his principal's goods or property of which he is not entrusted with possession or document of title thereto. He is a mere negotiator only, a mere negotiator between such persons with no possession of the goods. He has no possession for the goods or the property. He lacks the power or authority to determine whether the goods belong to the buyer or seller, and no legal or power to determine whether the goods should be delivered to the one or be kept by the other. He is just a negotiator only. He cannot really be more than that. Del-Creditor agent. Del-Creditor agent. A Del-Creditor agent is one who, in consideration of extra remuneration, called a Del-Creditor excuse me, a Del-Creditor commission, guarantees to his principal that third parties with whom he enters into contract. So he cannot really enter into a contract for and on behalf of the principal shall duly pay any sums becoming due under those contracts. The element of extra remuneration by way of Del-Creditor commission is indispensable to the establishment of a Del-Creditor agency, and it is the feature that mainly distinguishes it from any other agent. Now we are going to talk about types of agency. Actually, we talked about the types of agency, but just for a reminder, agency by agreement or contract, agency by agreement or contract. This occurs in a situation where the agency agreement is formalized by the express intention of both parties. The principal appoints and the agent consent. In the ordinary law of agency, the paradigm is that in which the agent and the principal agree that one should act for the other, and the term agency is assigned to this basic principle, which involves consent of both parties. So we have to have a consent for both parties as well. Excuse me. Agency by estoppel. This is the second type of agency. Agency by estoppel. The general position of the law in this area is to the effect that where a supposed principal intentionally or otherwise causes a third party to believe that another person is his agent, and the third party so relies in dealing with the supposed agent. So he's supposed agent, not real agent. The principal will be stopped from denying the existence of any agency relationship between him and supposed agent. So he had to verify and to accept this kind of agency. In such a situation, the supposed principal will be bound by an act or omission of the supposed agent to the same extent as if any agency relationship had existed between them. In a case, it was stated that when a person behaves in such a way as to lead another person to believe that he has authorized a third person to act on his behalf, and that the other person in such belief enters into transaction, of course business transaction, with the third person within the scope of such ostensible authority, the first mentioned person would be stopped from denying the facts of the first person's agency. So he has to accept it actually, because it's supposed and there is a real transaction happened between the two of them. It would not be material that the agent had no authority whatever in fact. Okay, we are going to talk about agency by ratification. Agency by ratification. This occurs in a situation where a supposed agent portrays himself to be representing a supposed principal whose consent he might not have secured, and the principal, on becoming aware of his assented to the transaction. The action of the principal is dominant to ratification. Agency by necessity. Agency by necessity. This occurs in a situation where a person acts in good faith as regards the property of another with the intention of protecting the interest of the owner or that of the general good. Such an agent will be regarded as an agent of necessity. So necessity is the main thing in this transaction or this agency actually. Generally, the courts are reluctant to find that an agency of necessity exists because it imposes obligations on someone who has not given consent to the supposed agent to so act. So courts actually reluctant to this kind of agency, which is agent by necessity or agency by necessity. Conditions for necessity of agency. The existence or otherwise of an agency of authority is dependent on the fulfillment of certain conditions, and these are: number one, that there is an emergency situation necessitating instantaneous action. Number two, that it was impossible for the claimed agent to communicate with the presumed principal at the material time. Number three, or the third condition, that the action taken was reasonably necessary having regard to the circumstances in the case. Number four, that the claimed agent acted bona fide and in the interest of the presumed principal. Duty of agent. We are going to talk about duty of agent. Duty of agent. Duty to perform. Duty to perform. The primary duty of an agent, particularly where he was appointed under an agreement with the principal, is to execute his agency in accordance with the terms of such agreement. So we have to have an agreement between the two of them. It is the duty of an agent to carry out the business he had undertaken. So he had due responsibility toward his principal and toward the third party. This was his obligation unless he had in his contract expressly excluded responsibility. If he had such a thing in the contract, in his contract, so it's excluded from his contract. I mean, the responsibility excluded expressly from his contract. Duty of obedience or loyalty. Obedience or loyalty. When an agent is executing the terms of his agency, he is obliged to carry out such instructions as may be given to him by the principal relating thereto, and must be seen to act promptly. That is the duty of an agent, to carry out any instructions that may be given to him by the principal. This is very important, and cannot depart from such instructions even though he reasonably believed that in doing so he was promoting the interest of the principal. Duty of care and skill. Duty of care and skill. In the course of executing the terms of his agency, the agent of his agency, an agent is bound to exhibit such care, skill, and judgment as are required under the circumstances of their particular situations. The prudence which an agent is expected to show in the affairs of his principal requires that he should not involve the principal in a heavier financial burden where there is a available means of involving him in a higher financial burden. Accordingly to that, it was held that an agent who undertook to effect a policy of insurance on behalf of his principal is under a duty to do so at the most economical rate. Duty of personal performance. The basic principle of law in this regard is covered by the maximum diligence non potest delegare, which means a delegated power cannot be further delegated. So the power that he has taken or possessed from the original principal cannot be delegated to the other person or another person's. Agency relationship is one of confidentiality of principal and the agent, and the agent is generally expected to perform his duties as an agent personally, so as if the agent himself owns this goods or services.